Hi, this is immigration attorney Abisha Parikh. Thank you for tuning into my channel and my video. This video is going to go over the 4 most common questions that I receive when I meet with clients, potential clients, and a lot of the questions are based on misconceptions of the law. So I hope that this video can help clarify some of the questions you may have had. Okay, starting with the first one. I am a US citizen. Am I able to sponsor my niece, my nephew, my uncle, my aunt, my grandchild, or my grandparent for an immigration benefit? The answer to this is no. If you are looking to sponsor a family member based on a family petition, according to the American immigration system, you are only permitted to file a green card benefit for an immediate relative, and an immediate relative is defined as a parent, a child, or a spouse. So uncles, aunts, grandchildren, grandparents, none of those are included in these petitions. Of course, if you're looking to file an affidavit to sponsor them for a visitor's visa, you can definitely do so, but not for a green card benefit. All right. Number 2, is it true that the F3 and F4 categories are being closed under the Trump administration? For those who don't know or not familiar, F3 category is for children over 21 of US citizens, and F4 category is siblings of US citizens. No, there are a lot of rumors going around, and while processing times have become longer for these categories over the years, the categories are not going to be canceled or revoked anytime in the near future that I'm aware of. But a lot of time, depending on where we receive our news, I do get a lot of clients who are in a rush to file because they think that that category will be closed, or clients who have already filed who are worried that their category is going to be closed and it's been pending for a few years now. So what's going to happen to their immigrant petition for their relatives? So just so you know, nothing is happening to the F3 or the F4 immigration benefit category. All right, moving on. I am in the US on a visitor's visa and I want to stay in the US permanently. What should I do? I think I receive this question at least 5 times a week. It's a very open-ended question, but what I'm going to try to do is give you a basic layout of how you can be permitted to stay in the US legally. So in order for you to stay, once you've entered on a visitor's visa and you'd like to stay inside of the country, you are permitted to stay for the duration of your I-94. So I-94 is that stamp or that electronic documentation that tells you when you have to leave the US by. Usually you're permitted 6 months on your visitor's visa. And so if you would like to extend your stay for a valid reason, you've extended your travel plans, or you've wanted to extend time spending with your family in the US, you can request another 6 months with USCIS. You will have to file a separate petition for that. Most of my clients that bring this question to me are actually looking for a more long-term option. While in the US, you're only permitted to stay here legally if 1, you're on a valid visa category, 2, you're a permanent resident, or 3, you're a US citizen. So assuming that you came here on a visitor's visa, the last 2 categories do not apply to you. So if you would like to stay in the US permanently, you would either have to extend your current stay, which only gives you up to a year max, or convert your status into another visa category. Converting your visa category is not easy. It's become more complicated and more tricky, and I'll go over that in another video, especially for those of you who want to convert your status from from visitor's visa to F1 I'll do probably a whole separate video on that because of the little minor details that really get overlooked in your application process, especially if you have the school or the institution or the university filing your change of status. But as far as changing your visa category goes, you could apply for a student visa if you'd like to pursue an education in the US, or you would have to switch into a valid work category. Again, this is tricky because if you're going to apply for an H-1B, for example, you would have to apply on March 1st. So if you're here at any other time during the year, you probably would not be able to apply for an H1 because that quota is closed within the first 5 days normally, after it opens on April 1st, I'm sorry. Secondly, you could try to convert to another work category, but these are all small niches. It really just depends on your eligibility. I would definitely recommend talking to an attorney before filing an application for a change of status to see if you even meet those categories. A lot of times I have clients asking how they can just get a EAD. It is not easy to get an EAD or work authorization in the US. Again, you do have to be on a valid visa category in order for you to be eligible. So definitely consult an immigration attorney. There are a range of visa options that could apply to you. But again, you would just have to find out if you would really be eligible. One small category that I forgot to mention is investor category. So if you are maybe eligible for an E2 or an EB5, that's another way that you can stay in the US and also work in the US. Again, these are significant investments. So a lot of times people do not choose one of these two categories, but I just want to throw it out there that they do exist. Number 4, I heard that if you do not have enough income, I cannot sponsor my spouse, my child, or my parent to immigrate to the US. So here's a scenario. You're looking to file an I-130 for an immediate relative, but your income doesn't meet the minimum poverty guideline. In this case, you still have to file a affidavit of support since you are the original sponsor on the case. Even if your income is 0, you still have to file an affidavit of support. However, you can add a joint sponsor to help you, to add their income to your income to sponsor your family member or family members to come to the US. The joint sponsor must be either a US citizen or a green card holder. They do not have to be relatives. It could be a family friend. So there's no requirement that it has to be another immediate family member that can sponsor or as joint sponsor your family members for your petition. What they basically do is take the joint sponsor's income, their household size, add the number of household members that would be added into the file, the intending immigrants, and they would see if their income meets the minimum poverty guideline. Again, the same procedure as for you, and they would do it for your joint sponsor as well. All right, so those were the 4 most common questions that I received. I hope you enjoyed this video. If you did, please like and subscribe. I'm going to try to post regular videos regarding common issues that come up in immigration law. So stay tuned.